Thank you for joining us for our second anniversary celebrations as the Center for Trade and Investment Law. As we enter our third year, we would like to thank the Trade Policy Division, Ministry of Commerce and Industry for their continued support, patronage, and the trust that they repose on us on an everyday basis. We thank the Honorable Commerce Secretary, Dr. Anup Wadhawan, the Additional Secretary, Mr. Sudhanshu Pandey, former Chairman, Appellate Body, Professor Peter Van den Bossche, for joining us today. I understand that the Professor and Dean Administration IFT, Dr. Vijaya Katti, will also be joining us shortly. And now I invite Professor James to address us on this momentous occasion.
Thank you, Prakhar. It is actually a distinct pleasure for me to welcome all of you to this dusty, Wednesday evening. But anyway, let me actually welcome Commerce Secretary Dr. Anup Wadhawan, Additional Secretary Mr. Sudhanshu Pandey, then Professor Peter Van den Bossche, currently Director of Studies at the World Trade Institute and former Chairman of the Appellate Body. Dr. Vijaya Katti hasn't arrived. I think she would be here anytime soon. So let me tell you, I think for any institution, 2 years is actually a very short period. It's a very short period, and we did not really want to have a celebration at this moment. But my own feeling is that, celebration is only meant when you are either too young or too old. And we are only 2 years old, and at this stage of infancy, it is a good thing to reflect upon what we have done so far and maybe to chart out what we can do in the future. So when we think about the Center for Trade and Investment Law, most of you know that it was established by the Minister of Commerce and Industry way back in 2017. In fact, exactly 2 years ago, I assumed the charge of head of Center for Trade and Investment Law, and then we hired a few people. The purpose of the center is to provide a kind of a neutral and objective opinion on international trade issues, to make sure that the government of India or the related agencies within the government actually work within the framework of the WTO agreements. So for some of you sitting here, this may actually look pretty strange, because in modern times, unfortunately, liberal trade is on the back seat. So most of the countries, and I think some of the powerful countries, are trying or actually doing their best in violating the treaty terms rather than observing it. It is a major concern, but our feeling is that this is a short-term hiccup. This will change over a period of time. Better sense will prevail. So while talking about this center, and I should really salute the sagacity within the Ministry of Commerce and Industry. I don't think that any other country, sometimes some of the countries may have a far bigger team of lawyers advising the government, but to create a think tank of this size and nature, and to have 5 different think tanks subsumed under the CRIT is a phenomenal achievement. And I would definitely salute not only the current Commerce Secretary, but even his predecessor, Madam Rita Teotia, and also the earlier Commerce Secretary, Mr. Rajiv Kher, and Ambassador Mr. Deepak as well. And of course, I will have to specially mention Mr. Sudhanshu Pandey. He has been the pillar of support for the center. Let me tell you, the center has been able to do or achieve certain very small milestones only because of him. He has been absolutely supportive of the center. So what we have done in the last 2 years, we should say that our center is a fairly small center. So we are very small, and we remain to stay small and humble. But at the same time, we have given around 180 opinions, 180 legal opinions. We have run major training programs so far. And we have also done a large number of stakeholder consultation events. So I believe that given the nature, the size, and the strength of the institution that we have, it is a modest achievement. At the same time, I should also say that we actually maintain a youthful profile. So when we think about most of the people, they are fairly young, they are straight from the law school. And sometimes I wonder whether the government of India takes our opinion seriously. So as poet Rudyard Kipling once said, when others doubt you, you have to give allowance for their doubting too. So this actually gives us a huge amount of responsibility to work harder, to make sure that our opinions are balanced and neutral, and examines an issue really well. So going forward, I think my own feeling is that the next year will be critical for the center because we are getting into some kind of a tailspin. The international trade order, the liberal trade order is facing a huge trouble, and unfortunately there will be actions, tit for tat actions, retaliatory actions, unilateral actions. We can't wish them away. So in this area, I would like to say that our center would like to tread a particular path which is actually based on the rule of law. Because what we believe is that whatever has happened in the recent times is only a blip. It can never continue like this. People believe in security and predictability. They believe in the triumph of rule of law. And if it actually happens, I believe that our center will have a far greater role to play in the future as well. So let me tell you, some of my law firm friends are here. We would like to work with you. And we would like to create an ecosystem of competent, smart, globally aspirational young lawyers. I should also say that we have hired some really fantastic lawyers, but some of them actually leave for higher studies. It is a sad thing on the one hand, but at the same time, I believe that they will be working in Washington, Brussels, or Geneva in the future, and spreading the gospel of international trade law and rule of law. So we will be really grateful for all the hard work that we have received from the research fellows and our think tank, our consultants. That has been just phenomenal. Lastly, I would say that this is not a celebration. I would say there's too little to celebrate, but this is actually a Thanksgiving. A Thanksgiving to all of you who helped in supporting the center, in making it what it is today. And we hope that we can continue to work and meet the requirements of the ministry and also help in strengthening the capacity of the Indian law firms and the academia in going forward. With all this, I would like to thank especially Dr. Wadhawan, the Commerce Secretary, Mr. Sudhanshu Pandey, and Professor Peter Van der Bosch. Thank you very much.
Thank you, Professor, for putting the second anniversary Thanksgiving in perspective. I now invite Dr. Anup Wadhawan to address us. Dr. Anup Wadhawan is a senior bureaucrat and veteran in the Economic and Commerce departments. He was Special Secretary before he took over as the Secretary of the Commerce Department, and he has also held the post of the Director General Foreign Trade. For 6 years, between 2001 and 2006, he was a director in the PMO. So we have the pleasure of having someone in the room who has worked both under Mr. Atal Bihari Vajpayee as well as in Dr. Manmohan Singh's PMO. Thank you, sir.
Professor James, Professor Bossche, my colleague Mr. Sudhanshu Pandey, and my dear friends and colleagues in the audience. It is indeed a pleasure to be here. My thanks to Professor James and his entire team for making it possible. And I'm indeed delighted to be part of the second anniversary celebrations of the Center for Trade and Investment Law. And I would disagree with Professor James. There is much to celebrate, even though it's been a very short period since the institution came up. But I think in that short period, it has proved to be really invaluable, at least from our perspective in the government. And there is much to celebrate. And I'm sure, as Professor James said, with increasing complexity, increasing chaos in the global trading environment, the importance of the center will only grow over time. And of course, I have no doubt on the capacity of the center to deal with all these challenges and provide us the best possible support that is possible within the profession of law. Law typically has in some ways always been very important in the government, legal issues, but they've been important from an administrative perspective. And it's been important mainly in terms of the perspective of defending the government for the legal consequences of its actions. So legal work in government is typically defensive. I'm not saying that we do things invariably in such a way that it invites legal complications, but there is some truth in that. The scope of government's functioning is in some ways all-encompassing. It affects so many areas of life. It impacts virtually every section of society, and consequently, leads to legal issues cropping up. So typically government focus has been on dealing with these issues and defending government in courts of law. In the trade field, in a global sense and in an international sense, the legal issues, the legal aspects have been emphasized overseas. But in India, the realization that trade negotiations, investment-related negotiations are areas of work which involve intricate legal issues, that realization has come late to us. If we look at our history, I think we negotiated very, very far-reaching agreements which we have to live with today without the kind of legal support that should have been there. I was today reviewing our entire approach to notifying our agriculture subsidies, and I discovered that there were so many legal options for us, even within the ambit of our policies the way they are, without changing a single policy, simply using those legal provisions, reporting the data in a certain format, reporting it in a certain context would have saved us a lot of grief. So in some ways, we are learning the hard way as to the importance of being legally sound in negotiating our various trade agreements, especially at the WTO and with various countries, and then of course using those agreements in a manner that is most advantageous to us, and then in spite of that, if there are disputes which arise, which invariably will arise, dealing with them in the most effective manner in our own interest. So I think this realization in some ways has come the hard way, and then has also come through support of CTIL. At least I, for one, over the last 2 years have learned a lot from all the inputs which we got on various issues, various negotiations, various disputes, and I thank Professor James and his team for that support, which is invaluable. And of course, as these issues come up in a more pronounced and greater volume, given the complexity around us, I'm sure the center will be able to enhance its resources, will be able to get the brightest young law professionals that we have in the country and sort of address the greater volume of work, address the greater complexity of the work. So talking of that, till recently we were concerned that a lot of negotiations were facing a kind of stalemate. There was no forward movement in the negotiations. WTO especially, the Doha round was not progressing well. Most negotiations were not progressing well. And developed countries in particular had a change of heart on development being the focus of the global trading arrangements, development being the focus of the rules we were trying to negotiate. But now we've gone a step further back. We are even questioning the existing agreements. The unilateral actions of certain countries have undermined the very basis of those agreed agreements. Invoking the security clause in an area where 70%, 80% of those products are produced in the US. 70 to 80% of US steel and aluminium needs are met by US itself. And the balance 30%, I think maybe 25% is coming from very, very close allies of the US, to then invoke a security provision and undermine the entire basis of WTO rules, opening the door for countries to, merrily in any situation use that provision and undo the entire system of rules that's in place. So that is the complexity which is very, very hard to fathom. And of course, the mechanism for enforcing WTO rules, which is the dispute resolution system, that mechanism itself is on the verge of collapse. The Appellate Body, I think by the end of the year, the way things are going, the quorum will be gone, and you'll have, in the next year, we'll have just one member in the Appellate Body. So the formal system of dispute resolution will in some ways be non-operational, and then what is going to happen is that the dispute panel findings will be subject to bilateral negotiation, I suppose. They'll be subject to, the mutual leverage that countries have over each other. Some will have more and some will have less, and how those outcomes will emerge. In some ways, we'll be in the pre-WTO age when 3-4 big countries decided how the rules would be, how they would be implemented, and everyone else sort of fell in line. So clearly we are reaching a very, very difficult situation. A lot of ad hocism, violation of rules, inappropriate use of political clout, economic clout in the trade sphere. So certainly I think the center will have its work cut out for itself, and it's reassuring for us to have the resources of the center behind us. And I must once again thank Professor James in particular for his personal contribution. Of course, anyone in his place would have contributed, but the fact that he was there made a difference. The quality of the support we got, the kind of cooperation we got, the kind of willingness to stretch the available capacity, in a sense, even at the cost of inconvenience to the smooth functioning of the center. Professor James has gone out of his way to help us in various issues. So my particular thanks to him and to his entire team of very bright, very enthusiastic young professionals. I was just seeing the sort of CVs in that brochure which is there.
Right.
So my compliments to all of you and my congratulations to all of you, and let me not say too much more now. Let me just conclude by wishing you all the best, and also saying that we are always there for you with any support you want, any additional resources you want, any difficulties you face in your work. Of course, Professor James can resolve most of them, but if there are some difficulties that we need to help you with in terms of resources, etc., certainly our doors are always open. So thank you so much.
Thank you so much. Thank you.
Thank you, sir, for emphasizing the strategic importance of international legal rules and giving us the assurance that there's always someone to reach out to. I now invite Mr. Sudhanshu Pandey, who is the Additional Secretary. He belongs to the Jammu and Kashmir IAS batch of 1987. He's also an MBA in Financial Management from the Indian Institute of Management, Ahmedabad, and Reforms in Government from the Indian Institute of Management, Bangalore. Among his earlier stints, Mr. Sudhanshu Pandey has also held the position of Managing Director of CITCO. Sir, I request you to address us.
Thank you very much. Thank you very much to Professor James for inviting for this beautiful function. I think celebrations was certainly due, and due in very befitting manner. And Commerce Secretary has already given his blessings both for the work that has been done by the center so far and the future promise that the center holds. Welcome to Professor Peter, who has been very active in this field for several decades now, and he has been chairman of the Appellate Body in WTO and has given many important judgments. I would just like to share a couple of thoughts with which this center was created, and what we see that how the center can contribute to the government, to the legal profession, and to the legal education. Now when the center was being created, then we saw much bigger role for center, and it's already moving in that direction. First and foremost was that it was supposed to provide legal critique, analysis, understanding of various complex trade and investment related issues to the Department of Commerce, and that has been very ably done by James and his team for last 2 years. Beyond that, the Department of Economic Affairs also saw a lot of value in the work that the center was doing, and therefore they signed an MOU with the center to work for them also, which we greatly value and we encourage. We also want center to develop capacity and expertise within the country as well as beyond national borders by following hub and spoke model, by tying up with various centers of excellence in certain areas, because in today's day and age, it is not possible to have expertise at one place. Expertise is available globally, and those who can tap that successfully in time will be more successful. It is not possible to develop expertise in every area yourself. You will have to rely on the expertise of people who are in different parts of the world, in different institutes, who are working in different areas, and that is what we would expect that center would be doing in future. It's already on that course, and they have had some relationship with an institute in US. They are working towards relationship in Switzerland, in Bern, and within the country also we would like with national institutes and other centers of excellence, with law firms, both public as well as private. They should be in a position to harness that potential and expertise that exists. Going beyond that, 3 areas, one Commerce Secretary has already mentioned as to what is the trade environment today and what are the challenges. And when wars are fought, even then rules are followed, but those rules are different. And you have seen that in First World War, Second World War, those were the typical wars. But even in trade war, I am sure certain principles would emerge and countries would realize that even trade wars have to follow certain rules, because ultimately the people, economies, they would suffer damages, consumers would suffer, trade would suffer, growth would suffer, jobs would suffer, and therefore it is not possible to stretch that beyond a limit. And therefore, certain principles will have to be followed sooner or later to draw the boundaries. I am convinced that that will happen sooner rather than later. But what is more important, greater challenge that I see for the legal profession is essentially the technology. Today, it is extremely difficult for law to keep pace with the fast-changing environment technology, and digital technology in particular is so disruptive that it is not possible for governments to frame policies, it is not possible for governments to frame rules, legal framework, and technology is outpacing all of them. As a result of which, what is happening, that the framework is being developed, is being thought of at global level. And when that framework is being thought, the interest of developing countries or countries who are vulnerable to such disruptions are also not getting protected, they are getting compromised. So how do you bring that balance in the law is also going to be challenged. And here comes my third favorite subject on which I feel very strongly, change in the legal education in India itself. And that when I say that, I essentially mean that today you need lawyers with all kinds of background. You need lawyers with technology background, you need lawyers with the bioscience background, you need lawyers with pharma background, and unless that flexibility is brought in the curriculum and the courses, it will not be possible for lawyers to actually suggest and frame laws and frameworks which can keep pace with the changing pace of the technology. This is one area I have been telling James that you have to work with BCI. We have been engaging with them that this is something which needs to be done, and we have to learn from the West where all kinds of combination, all kinds of options are available, and you can pursue and you can contribute in any of the areas. This is one area. Last area which is very important, on which center has been working, but we all collectively need to work a little more, is the future of the legal profession itself. Now this also needs a lot of changes in future to come. We are still in an age where whatever we inherited in shape of various laws, beyond amendments, no major structural reforms in the legal profession itself has happened. And when I say that, what I am referring to a common law system which we followed from Britain, and Britain itself took complete reforms in 2006 by bringing Legal Services Act, where they started treating, it's also one of those services which are now consumed by people. We still continue to treat law a noble profession, very good, but this nobility is within the courtroom, but when you deal with the consumer to whom you are rendering services, you also need to follow certain principles, you also have to be accountable. All that is missing today in India. Clients' interest, consumers' interest are secondary. Law firms' accountability, sorry, there are a couple of them sitting here, is missing. If you render wrong advice which leads to a lot of financial and other consequences, there is no provision to compensate you, or you take a very long legal torturous route to pursue through the normal petition, outcome of which is uncertain. Now these are major areas on which we have created certain resource papers, we have been discussing, and I would request Professor Peter von Bossche, who has actually, I was going through his resume, so from Turkey to Europe to US to Africa, he has been working all over. So he brings with him all kinds of experience that is needed actually to bring those reforms in India also. And I personally feel very strongly that today India, despite producing second largest number of lawyers, advocates, licensed advocates after United States of America in terms of number, contributes less than 1% to the total legal service trade globally. Now this is beyond my comprehension, and I want this young, bright population to get professionals, to get an opportunity. They are doing extremely well globally, and I see no reason why they cannot do well in India. So with these expectations from Professor James and his center, I would like to wish him and his entire team the very best. 2 years is a very short time in which you have delivered so much. With the support that we get from the Commerce Secretary, I am sure all your problems, which are initial infancy problems, can certainly be taken care of, and you can be given full professional freedom to pursue excellence. Thank you very much.
thank you, sir. We hope to fulfill the larger role that you have given us today. As most people who have attended the training session and even during the Commerce Secretary's speech, the Appellate Body crisis is something that has been talked about a lot today. And we are fortunate to have perhaps one of the most qualified people on the planet to speak on it, someone who can provide an insider's perspective. We have, of course, the pleasure of having today with us Professor Peter van den Bossche, who is the Director of Studies of the World Trade Institute and a Professor of International Economic Law at the Faculty of Law of the University of Bern, Switzerland. He has served as the President of the Society of International Economic Law, and he was a member of the Appellate Body of the World Trade Organization from 2009 to 2017 and served as its chairman in 2015. So, we look forward to it.
Dr. Wadhawan, Mr. Pandey, Dean, VIA, my colleague and dear friends, James, ladies and gentlemen. It's an honor for me to speak to you at this event. The event marking the second anniversary of the Center for Trade and Investment Law. To speak here is an honor. But it is also a source of great satisfaction to sign later a memorandum of understanding for enhanced cooperation between the Center for Trade and Investment Law and the World Trade Institute. In these challenging times, this kind of cooperation, the cooperation between our institutes, is more welcome and more necessary than ever. These are indeed, as was already said by the speakers that preceded me, these are indeed very challenging and uncertain times. What was self-evident yesterday is now being doubted. Who believed a year ago that we would be facing today a trade war between the United States and China that would affect $360 billion of trade in both directions? Who would have believed a year ago that in June 2019 we would be counting the days to the point that the WTO dispute settlement system would gradually collapse? Who would have believed that a year ago? There's fortunately a general recognition that the WTO needs to modernize, that the WTO needs reform. I refer to the European Commission's concept paper and Canada's proposals, Canada's position paper, both of September last year, and China's position paper of December last year. While India has often spoken out very forcefully in support of the multilateral trading system, it might be very useful for the rest of the world also to see a position paper by India. The fact that we need reform, the fact that the WTO needs to modernize, was also very well reflected in a, for the rest, very disappointing G20 statement on trade and digital economy, the outcome of the G20 Ministers of Trade over the weekend. We need reform. And I think we need reform in 3 areas. And you see that reform in 3 areas recognized in the position papers that I just talked about. We need reform we need reform of the rule-making / negotiation function of the WTO. And many of the countries that currently have put on the table proposals, opposition papers for that reform, tell us that we need to negotiate and that we need to focus the negotiating agenda on what they call 21st century trade issues. New rules on subsidization, new rules on state-owned enterprises, new rules on e-commerce, better rules on IP protection, rules on special and differential treatments, different from what we have now, reconsideration of the developing country status. These are issues that are being put on the table by some. I suppose that in the week that I've now spent, week and a half almost, that I've now spent in India, I have understood that India might agree with the need to talk about some of these issues, but that India also considers that some of the old issues, some of the inequities of the current trade law need to be addressed. And I couldn't agree more. With regard to the reform of the rulemaking / negotiation function, the question of course arises how to approach these negotiations. How to approach these negotiations in these times of enormous differences between those that will be around the negotiating table, differences in willingness to engage in negotiations. Should we go for, at least try to go for multilateral negotiations? Or should we immediately go for plurilateral? And if we go for plurilateral, should these be negotiations that would eventually lead to a plurilateral agreement that will be applied on a most favored nation basis? Or should we even give up that? And should we go for plurilateral agreements that would only apply to the parties of those agreements, that would only benefit the parties to those agreements? And if we go down that road, what is left of our multilateral trading system? We also need reform, and that's a second area of reform. We need reform of the transparency function of the WTO, a very, very important function. Reform of the monitoring function of the WTO. And I will only mention 2 things. First of all, we need to beef up, we need to improve the working of many WTO committees. There are committees that have done very, very good work. The SPS committee, the TBT committee. We should see this good work also be done by other WTO committees which have been less active. I think we should also look at the notification requirements. And I know that's perhaps not the most popular thing to say here, but notification go hand in hand with transparency, and transparency is extremely important to have trade. There's no trade without transparency. There's no trade without traders actually knowing what the rules are that are going to be applied to them. So you need transparency, and transparency requires good notification. Perhaps the proposal that is currently on the table, the proposal backed by the United States, the European Union, and Japan, and one or two others, has too much stick and not enough carrot. But at least it's a good start of an important discussion. The last area where we need reform is, of course, dispute settlement. There are currently 22 WTO members that have either individually or in groups put forward proposals for the improvement of, in particular, appellate review. They are addressing concerns that have been voiced by the United States with regard to appellate review, concerns that have led the United States to obstruct the appointment of appellate body members. An obstruction that, as already pointed out earlier this evening, an obstruction that will lead in December of this year to a situation in which the appellate body will no longer be able to take new appeals, which in itself then will lead to the gradual collapse of the WTO dispute settlement system. The proposals for reform of appellate review that are currently on the table, I would like to divide in two groups. There are some proposals, and that includes the proposal that was co-sponsored by India, proposal by the European Union, China, India, and a number of other countries, and then another proposal that went even further, again co-sponsored by India, but together with the European Union and China. These proposals are proposals that are quite positive. To a large extent, I would wish that these proposals were not necessary, but they will definitely not do any harm to the system as we know it, and on some points would improve it. There are other proposals on the table that will destroy the system as we know it, that give in to the narrative of the United States that there is something fundamentally wrong with WTO dispute settlement, and in particular with the way in which the appellate body has performed its function over the last 20 plus years. Now, you would expect for me to disagree with that, but with me, most people would disagree. Most WTO members disagree, except for some, and they have tabled unhelpful proposals. The most helpful proposal, to go back to the good category, the most helpful proposal currently on the table is a proposal by Thailand. And I invite you all to read that proposal. It's an April proposal. And truly, if that were acceptable, we would be out of the crisis. Acceptable to the United States. Unfortunately, the United States is not engaging in the debate at all. They make statements in the General Council, statements such as, well, the appellate body just has to respect the rules of the DSU. Obviously, nobody would debate that. The question is that we have another understanding of what these rules require. The United States does not get involved in the detailed discussions on the proposals that are currently on the table to address their concerns to the, what is in technical terms called EU meetings. They merely send a note taker, a junior diplomat that takes notes of what is being said. This crisis is not going to be resolved in time. In December, we will no longer have a functional appellate body with all the consequences that that has on the rest of the system. It will not be resolved because I don't think that the United States has any interest in resolving the crisis. Robert Lighthizer said so much in a statement that he made in March to the Senate Finance Committee, he said the appellate body and that whole question, that's leverage for us. It's leverage for broader WTO reforms. And he didn't specify what he actually had in mind, but I think he was talking about broader WTO reform on substantive provisions, such as in the trade remedies field. So, don't get your hopes up on a quick resolution of this crisis. So what will happen? Or what may happen? What can we do as from the 11th of December onwards? Well, first of all, I think that while there cannot be any new appeals, no new appeals, the appellate body will still operational for quite some time. Because the two outgoing WTO members, they will continue to function under Rule 15 of the working procedures. Just as I, after my retirement in December 2017, functioned as an appellate judge for another 1 year, 3 months, and 3 weeks, counting. So they will continue. And given the queue of cases that is currently already considered by the appellate body, and the panel reports that are likely to come out before December, the appellate body will be busy for another year, a year and a half. And that may be a blessing, because that will buy us a little bit more time. But don't be over-optimistic, because any panel report that comes out after the 10th of December, those panel reports, well, there will be no appeal process for these panel reports. So what do we do about these panel reports? Well, there are currently 2 proposals on the table, or 2 ideas. It would be too much to say that they're both in the form of a proposal. One is in the form of a proposal, the other one is more an idea. The idea is the following, and the idea apparently has some support in India, is that both parties agree not to appeal. So at the beginning of the panel process, they will agree not to appeal. And if you agree not to appeal, then of course the panel report, non-appealed, can go to the dispute settlement body and can be adopted and becomes legally binding. The other idea, and that has now already been translated into a proposal by the European Union, the other idea is to have an appellate arbitration, an appeal arbitration, under Article 25 of the DSU. Article 25 is a provision that has once been used, so far in this 25 years, it's once been used, and that provides for arbitration as an alternative to panel and appellate body proceedings. Nobody had really thought about just having it as a replacement of the appeal process, but that's the way in which the European Union is now going to use it. Their proposal talks about an ad hoc use of that Article 25, meaning that for each dispute they want to use it. Well, I think it suffers from the same problem as the agreement not to appeal. It really does. What is the problem of both solutions? The problem of those solutions is that the respondent in most cases won't go for it. Why is that? Well, statistically, respondents lose cases. And not just a bit. 90% of the cases is lost by respondents. And this is not going to be any different in the future. So if there is a case that is brought against you, as a respondent, are you going to agree in the beginning of the panel process not to appeal? Or are you going to agree to go to an appeal process under Article 25? You try to sell that to your minister. Yeah? Because you're then going for a situation where the panel report that is most likely going to be against you can be adopted, or you're going to go for a situation in which the panel report will then be appealed, and the appellate body, while they often make changes, but often does not fundamentally disagree with the finding of inconsistency by the panel. Now again, you will end up having a report that goes against you, while you have the possibility to have a panel report that will never become legally binding. I let it to you to decide what is politically most likely to happen. I think both of these solutions are maybe, in some cases, a possibility. But in most cases, respondents will not go for it. So, what does this mean? I think that, as I had the occasion to say in my farewell address to the WTO members 2 weeks ago, I think WTO members have to reflect very carefully as to whether they do not want their disputes between Brazil and the European Union, disputes between the European Union and India, between India and Indonesia, between Indonesia and Brazil, there are many disputes out there that do not involve the United States, whether they want those disputes to be resolved in an orderly and rules-based manner. And I think the answer to that is yes, that's what we want. And if we want that, I would suggest that, and that's not for tomorrow, but for the day after tomorrow, I would suggest that a coalition of willing WTO members creates a dispute settlement system that copies the DSU that by that time has become completely dysfunctional. Is that a great solution? No, it's a third best solution, but at least it keeps disputes between many countries. It gives us the possibility to resolve these disputes in an orderly and rules-based manner, as I already said. The WTO dispute settlement system has been, and I think at the moment still is, a unique and glorious experiment with the rule of law in international relations. We may lose it. And as I concluded my farewell address to the WTO members, history will not judge kindly those that are responsible for the demise of the WTO dispute settlement system. Thank you.
Thank you, Professor, for the realistic assessment of the state of play in dispute settlement. I now invite Professor Vijaya Katti to address us. Professor Vijaya Katti is a professor and the chairperson of the Indian Institute of Foreign Trade. As the senior most faculty in the institute, she is also the chairperson of the MDB program at IIFT, and she holds a PhD from Nagpur University and has completed a postdoc research from JNU. Ma'am?
honorable dignitaries of the dais and the distinguished audience in this particular hall. Good evening to you all. It's indeed my pleasure to be here with you all today on this particular occasion, which is really worth celebration. In fact, WTO is here, it's going to stay. The mandate is vast, it is expanding, and whatever are the legal provisions which are there, the knowledge and understanding of that, the legal connotations, implications of India in all the matters in the context of these WTO agreements, it all becomes very, very important, and especially in the context of an institute like IIFT, which has been into the training of different candidates at different levels. James has always been a constant pillar of support. He is here as a center head for last 2 years, but for last more than 2 decades, he has been involved in IIFT and IIFT's training programs, which we have been organizing on the area of in the area of WTO. Initially, we have been conducting various programs for trade, industry, government officials, IAS officers. Initially, it was WTO orientation programs, because when WTO was born, and it was at that time I was trying to locate somebody, because we really wanted people who knew about WTO. And at that time, somebody with the understanding of the legal issues and the legal connotations, I tried to find out, and from various sources I got only one name, that was Dr. James. And since then, I remember that whatever has been he has been traveling a lot, whatever lecture we invited him, he came. And he had been traveling, he came, he was telling me, ma'am, I've come by the morning flight, but I've come here for the class. And he would travel about 30, 40 kilometers, but he would come there. And the notable point here is his deep knowledge and understanding of the subject. The students would always get highly impressed. We had the MBA full time. It was a compulsory course at one point of time. He contributed. Then it has been turned into an elective. He came. Now, in between, there was a little lull in the sense that the participants were not too much interested, because little bit for some time they felt that nothing was happening, and the matters were not moving forward. Now again there is a interest, and he has agreed to be there as a resource person. So not only in that, so in terms of the WTO related issues, but he has always taken a lead in organizing different events on behalf of this CTIL. How should WTO members respond to the WTO governance and Appellate Body? Then the Congress on Foreign Direct Investment, workshop on investment treaties and investor state dispute settlement system. Then the panel discussion on shaping the future of WTO, discussion on recent developments in international trade. He has himself been a prolific writer. He has published books, he has published the papers in journals, and I have been a part of many of the celebrations and many of these discussions, panels and the discussion forums, etc. for this CTIL. So I have seen, and he has been collaborating also with various organizations where it is the India's exports, India's international business, the negotiations, the elements, the subsidy part. So talk about anything, this, and now for last 2 years, I can really see that there has been a tremendous contribution of this particular center. Couple of years back, when we knew about this establishment of different centers under the WTO center, I came to know that he is going to be the head of this center. So I thought that probably none of the other name would have been more appropriate for being the head of this. This center has been contributing a lot to the awareness also. That particular part which I feel is very, very important, because knowledge has to be there, understanding has to be there, and everyone should know about it. but the awareness needs to be spread, for which lot of efforts need to be undertaken. And he, with his support system and the team, has been doing that particular work. It is so difficult to organize the events successfully, and this awareness which he and his team is trying to create amongst the stakeholders, that probably is something which is one of the most important parts. India has a major role in all these matters. Since yesterday when I was discussing the issues with Professor Bossche also, there had been a lot of discussion about how this dispute settlement system is going to take shape, what can be the different alternatives, what could be the stand which India can take, what exactly would be the issues in future in terms of the changes in terms of the foreign trade policy which is going to come now, India's foreign trade policy, and take any issue. And then Dr. James has his own opinion, not only that, but he has been making the efforts also to involve variety of the stakeholders on different forums also. I think this is something which is a great work, and with the support of the Ministry of Commerce, this type of the initiative is not only helping the stakeholders, but an institute like IIFT, which is also training different stakeholders, training different participants at different levels in terms of various programs. At this moment, I can only say I wish you all the best, Dr. James and your team. Shubhaste Panthana Santu. Thank you.
Thank you. I think Dr. Katti has really embarrassed me. Thank you so much for the comments. Thank you.
Thank you, ma'am. Now to mark a small milestone in the infancy of our center, we are going to launch our new website, ctil.org.in, and I would request Honorable Commerce Secretary to use the wireless mouse, put right in front of him, to press the launch button so that everyone can see the new website. And please join me in a round of applause for this occasion.
Yeah, I think. Yeah. I think, yeah, just come down.
No.
Why did you assist?
Yes.
Oh, right. You had to click, I think. But I think it's thanks.
Thank you, everyone. That brings the program to a close. We have organized a few cocktails and dinner for everyone and the lawns outside, so please join us. Thank you so much for coming.